I'm very much happy to share with you some thoughts about the tensions between trademark and copyright in the context of logos. If we take the life cycle of a logo in practice and based on a partly fictitious example, if you take the oil company well-known Shell, they had, let's suppose, only a word trademark and wishes to have an emblematic logo as well. They contact a designer agency to draw the sketches, and within the agency, one employee, together with a consultant, drew the first logo in 1900. And regularly, as most of large multinationals, they decide to revisit their logo and to contact often new designers and new design agencies. And there is the evolution of the logo of Shell among the years. All are registered as trademarks, and we'll see whether these logos duly filed as trademark are nevertheless at risk. So as we all know, and I used the old numeration that will change as from the 1st of October for the sake of facility. We all know that logos are protectable under the trademark, so I won't go into the details in this respect. And prima facie, the filing of logo is quite streamlined and presents a lot of advantage if it's filed as trademark. First of all, we have within the EU IPO availability search, and there is a very useful database which enable any designer or company to make a search whether this logo already is registered. And I took the example of Instagram. So if you combine that with the possibility of opposition proceedings and the prima facie ex ante control of the EU IPO based on the absolute grounds for refusal, the risk of coexisting identical or chromatically similar logo protected by trademark is relatively low. Well, we all know the caveat of the well-known Sabel case law, but nevertheless, prima facie, there is a legal certainty. Once published, you have a title, which is very useful, for example, at fairs, that you can enforce against infringers. There is no time limitation, and there is, in principle, no limited assignment issue, since the trademark belongs to the person or entity who registered it. But there are a lot of flip sides with respect to trademark filing. It's a limited scope of protection because you only, with respect to the exception of well-known mark, can only challenge and dispute identical or similar product in similar classes. There is a risk of dilution, so you need to monitor the sign, which is costly. We spoke about the use of the trademark within the 5 years and the problematic of evergreening with respect to defensive trademarks. And it should be within the course of trade, with the notable exception of the Benelux Convention, where you can enforce trademarks even if it's not used in the course of trade. Registration is needed, no automatic protection, and it's a territorial limitation, country or region. Therefore, the cross-protection combined trademark and copyright is useful and very often not taken into account by IP lawyers. As if we go back to the logos of Shell, they are both protected by trademark, but potentially as well by copyright. And pursuant to the EU CGAU case law, any kind of work of art which is a concrete form and which bear the stamps of its author is a copyright protected material. And there are a lot of advantage that you do not have within the trademark, which is no need for registration. The protection is ensured progressively throughout the creative process and not as from the registration. There is no cost. The protection is quasi-universal through the Berne Convention. 174 countries has ratified the Berne Convention, and it protects all goods and services, so no classes. There is no course of trade prerequisites, contrary to trademarks, and although trademarks are unlimited protected, provided you pay the fees every 10 years, duration of protection with respect to copyright is 70 years after the deaths of the last authors. So if you have a collaboration, it's the last one that will count. But there again, there are caveats, especially with moral rights. In most of the country, it's the same duration of, but in France, for example, moral rights will survive ever. And so there is no statute of limitation with respect to moral rights in France. But there is no database for availability search. So you do not know whether someone else has designed a similar logo or artwork besides checking on Google, but it's a limited reliability on that. And since there is a universal protection, you're supposed to make a worldwide check. Everybody could at some stage, and we will analyze an interesting case study with respect to logo of the International Olympic Committee a bit later. But the thing is that contrary to trademark, where you have ex ante control by the EUPO and the national IP offices, you do not have that with copyright. It's ex post check, so you're not sure that your logo will be considered to be copyright protectable. And the threshold for copyright protection is not harmonized within the EU. As we know, in the Benelux countries, the threshold is extremely low, a bit higher in France, but still always quite low. But in Germany and Spain, only iconic elements are copyright protected, especially with industrial design. There are also, with respect to the assignment of copyrights, numerous differences. For example, in the example I gave at the beginning of my talks, that the first logo of Shell was conceived by one employee and one consultant. In Belgium and France, there is a presumption, there is no presumption of assignment of the copyright to the employer unless it is with respect to copyright through the software directive. But for normal copyright protected material, there is no presumption of assignment. In most of the other countries, and specifically Netherlands, UK, Ireland, and Germany, there is a presumption. So again, you have then to check what was specified in the employee's contract of the designer that conceived the first Shell and the next Shell logos, which means that possibly Shell is not holding the copyrights on its own logo, which could be then challenged. We will see that if they are revisited because of a breach of moral rights. So these things are quite key. And another disadvantage with respect to moral rights is the way they can be transferred from the employer or to the employer or to the client. In UK and Ireland, they cannot be transferred, but they can be waived. in Belgium, they can be waived, but it's not a general waiver that's possible. And in France, they cannot be waived, which is a real issue, because if we take the shell example, I will here. If you start from the last line, it's obvious that all the 5 last designs are a revisiting of the previous one, which is basically a breach of the moral right of integrity. And if Shell has concluded a contract with an agency, as we know, the moral rights remains within the natural physical person, and not, since they are not transferable, which means that in the contract between the agency and Shell, the moral right could not be addressed unless you have kind of procurement terms or proxy order with the licensing of the defending and the exercise of the moral rights. But this means that, and on top of that, the paternity rights, where you're supposed to mention the name of the creator, is not mentioned on the logo, which is also another breach of copyright. So all these things need to be addressed, which means that most of the logo, in fact, are in breach of copyright. So there is a high risk of dispute due to those elements that I have explained. And just to give you an example of some logos that are registered as trademark, and the similar logos exist on Google which are not registered on trademark. So lots of possible dispute, quite nice for litigator lawyers. But how to respond to a copyright infringement proceedings? Let's suppose you have filed your logo as a trademark, and you have done an availability search, and you haven't found any other similar logo on the database of the EU IPO. So you think it's free, I file it. And you are sued by a designer in a remote country that states that he has an earlier right on copyrights. And at the end of the day, your logo filed as a trademark is a slave copy of that earlier logo. How can you defend? There is an interesting theory that is not so well known by IP lawyers, that is the independent creation. The burden of proof is quite high, but provided you are able to defend that you created your logo without knowledge of the earlier logo, there is no breach of copyright, although it's a slave copy. But and this theory not only exists in the different EU jurisdictions, but as well in Japan and in the States. But the burden of proof is extremely high. You need to bring the evidence of the creative process, the sketches, drawings, provided that it's unlikely that you knew that, let's suppose that in Madagascar someone was designing a similar logo that you have designed in Russia, for example. But the problem is that in our digital, fully digital economy, with all logos, or lots of logos accessible on the web, it will always be difficult to say that you couldn't have any knowledge of the existence of the logo. And let's suppose that, and that's a more probable case, it's that the trademark shows strong similarities with the earlier creation. There the defense that should be tried to put forward is that the earlier copyright protected logo is benefiting from limited copyright protection, because it is based on a special style. It is merely consisting of pre-existing alphanumeric or geometrical signs. The logo as a trademark was designed in accordance with specific guidelines in the context of a contest, etc., etc. But now let's apply that to a real case that you might have seen in the media 2 years ago. So the International Olympic Committee, as always, is organized. The local organizing committee is organizing a contest in order to select the new emblem of the future games. And so, as you know, the future games will be in Tokyo in 2020, and the winner of this contest delivered the logo that you can see on the slides. It was a Japanese designer, because usually those contests are open only to local designers. And once it was disclosed by Japanese media and by the IOC, a designer in Belgium who designed 2-3 years beforehand a logo for a local theater in a medium-sized town of Belgium. Nothing to do with sport. It's a culture, a cultural building and activity, and he initiates proceedings against the IOC, claiming that there was a breach of his copyright. Well, so delicate situation, because the trademark search didn't reveal any differences. It was filed as a trademark, and you're facing with that, and the risks are not negligible, because in all these big world sport events, there are sponsors who receive the license to use the logo, which means that there will also be infringers of copyrights. But when you face these kinds of cases, then you can start trying to see the only possibility is here independent creation. And so you start to try to find out the drawings of the earlier designer to see what was in these contests. Very often there is an evolution of the design, and if you can see that, in fact, the first initially submitted design was more different than the last one. And by digging even more, you could find that the inventor of the modern typography, it's a German citizen that escaped the Nazis to UK, and he's well known in UK and outside UK because he has found out the layout of the Penguin Pockets book after World War II. And Jan Tschichold was close to the Bauhaus, although much less well known that from the other professors from the Bauhaus, in fact invented a typography that is extremely similar to the one used by the author of the Théâtre de Liège logo, which means that who is counterfeiting who, since the work of Tschichold is still copyright protected. He hasn't died since 70 years. So there is base to say that first there is a limited protection on the Théâtre de Liège logo, and on top of that there is most probably independent creation. But unfortunately the case wasn't pleaded because at the pleadings hearing the plaintiff didn't appear. So we will never know. But it's, I think, very interesting to broach your analysis when you decide to file logos as trademarks, and perhaps how to limit the risk. Whenever you organize a contest for a logo, or whenever your client would request a third party to submit drawings, besides handling properly the assignment of rights and the waiver of the copyrights, the moral rights wherever possible, it is, I think, important that the authors detail the source of inspirations, file as attachment all the draft and sketches, so that you can have a better view of the creative process. And now, whenever you have addressed that properly, your client will be much more stronger to clean the market if needed, and to supplement eventually if his trademark doesn't enable him to sue a similar logo file as a trademark in another class. He could rely possibly on his copyright on the logo, because there is no class with respect to copyright. But the problem is that at E, and you can accumulate both, but the problem is that, as you know, the EU has now filed a new draft directive with respect to copyright, but it's a missed opportunity. They didn't address the further harmonization on assignment formalities, no harmonization on moral rights, and so far the threshold of copyright protection has not been harmonized, and there is no very important case law at the level of the European Court of Justice. And on top of that, in a digital economy, why should we harmonize these things at the EU level? It's possibly an interesting challenge for the Berne Convention that hasn't been revised for nearly 40 years. Thank you very much.